Another person. How could you do that to another person? How could one person do that to another? I don't know what was going through his mind. I don't know. Just can't believe it. Just can't believe it was him, especially 15-year-old with a shotgun.
More than 2 years since police say this teen opened fire on his own neighbors, even killing his own brother. For the first time, we see Austin Thompson in North Carolina court. But the wait for justice for the alleged victims of Austin Thompson will have to wait until at least 2026 after a judge's ruling in North Carolina court on Friday. Before we get to why this trial is being pushed back until next year, let's go back to October 13th, 2022, and how we got to this point. Police say on that day, the 15-year-old alleged shooter, Austin Thompson, first shot and killed his own brother, 16-year-old James. Here's a pic of them together per local TV station WRAL. He then allegedly killed 4 more people in his neighborhood. One of the victims was 52-year-old Nicole Connors and her dog on her porch. Here's what her husband, Tracy Howard, told the Associated Press in 2022.
She was just a kind person. She was a good person. She didn't deserve anything like this. No one does, really, but she's a good person. She took good care of me, took care of her family.
Howard told local media that he never had problems with Thompson. Sometimes they'd talk in passing about things like college football, as neighbors do.
Just when they walk by, I see them coming from school. How you doing? They waved back, or sometimes they didn't. But we never had any beef or problems with them. We just barely interacted with him. We talked to his father every now and then. That's about it.
Police also say Thompson killed an off-duty police officer on his way to work and 2 women who were on a nearby greenway. He also allegedly injured 2 others. Police would find Thompson with a self-inflicted gunshot wound to his head in a nearby shed. He survived, but he hasn't been seen since. That is until last week, when he appeared in court for the first time. You can see in this picture by WRAL TV the scar on his forehead. He's now 17 years old, and he is being tried as an adult. Originally, this trial was set to begin in September of this year, 2025. But the defense argued they needed more time because Thompson now suffers from a brain injury because of that self-inflicted gunshot wound, and also the mountain of evidence in this case the defense says that they need to go through. The judge granted them that motion, and now the trial date is set for February 2026. Even though it will be more than 3 years since police say Austin Thompson went on this rampage, there's been movement in a related case, and it involves his dad, Alan Thompson. He pleaded guilty in September 2024 to improperly storing a handgun that police say his son used in the shootings. Prosecutors say Alan kept a loaded handgun in an unlocked box on a bedside table. What's truly remarkable for a crime that has changed so many lives in Raleigh, North Carolina, is still at this point, we don't know why police say this teen did this. A motive has not been released as of yet. Joining me now to dive deeper into this case and the trial that is ahead is criminal defense attorney Satha Robinson Ferrer. Thanks for taking the time to be with us. What do you make of the judge siding with the defense to move the trial date now into 2026 for this case?
I think that the judge made the right decision. As cases are prosecuted and we start to head towards trial, one of the things that has to be protected is the record for appeal. There is a question at this point in time as to whether or not this individual is competent enough to stand trial. I believe that this individual suffered some sort of brain injury as a result of this unfortunate incident. And so what the defense is doing is essentially putting a pause on trial so that it will either allow their client to regain competency or to allow what's the best manner forward so that their client can assist in his own defense. And that's one of the things that needs to be done to protect the record on appeal, to ensure that this case does not come back down on appeal for any reversal. So I think that the judge made the right decision in siding with the defense and in protecting the integrity of the judicial system.
Because when Austin Thompson was in court this week, there's this scar on his forehead that presumably is from the self-inflicted gunshot wound that police say he suffered after this rampage they say that he went on. How could that brain injury, that brain damage impact the trial once it gets started?
Absolutely. So, one of the things that's so very important is that a defendant has a right to aid in his own defense. When a trial commences, the defendant, along with their attorneys, or for example, my client and myself, we work together to formulate our defenses and put forth our own evidence and proof. Not only that, but when the prosecution has witnesses that are testifying, we have the ability to cross-examine them. And there might be, an example that comes up where, so a witness is testifying to one thing, and then my client says to me, or the defendant would say, well, that's not actually what happened. This is what happened, and these are the questions, attorney, that you should be asking. Because this individual has that sort of injury, it raises a question on if he will able to do that with his attorneys, or again, assist in his own defense. So those are the things that could come up. That is why I believe the delay was granted, and should have been granted.
And as far as the process of going through evidence, because I know the defense talked about in their court records 8 terabytes of data of evidence to go through, which is just a massive amount. But as a criminal defense attorney, what is the process of actually going through that data, and how that time could be used to prepare for a trial?
Absolutely. So what happens is we get, the discovery either through portal or some other means from the district attorney's office, and we go through each and every piece of evidence. We go through every name, every police report, every piece of video footage, or audio surveillance, 911 calls, any and everything that was created under the sun with respect to the case. We go through each and everything. Then we sit and have a conversation, or at least I sit and have a conversation with my clients as to what was found. Not only that, but we also have a duty to investigate the things that we find in discovery. So not only are we reviewing it, having discussions with our clients about it, but we are also sending out our investigators to find additional information with respect to what we've seen in the discovery, or to negate what was said in discovery. We have the ability to have our investigators, and usually we hire out private investigators, to go speak to witnesses, to speak to law enforcement officers, and anybody that's expected to testify at a trial. So lots of information, lots of files, lots of things to get through, and we get through all of those things as we prepare.
I'm sure a lot of sleepless nights as well, because it's a lot of data to go through. You look at the charges that Austin Thompson is facing. He was 15 at the time police say he went on this mass shooting rampage in his own neighborhood. He's 17 years old now. Why is he being charged as an adult?
That's going to depend on the state statute, and each state, of course, is different. I think with respect, and I can only guess that, in the state that he's located in, there's a caveat that because the individual is charged with murder, or something that is a more heinous crime where an adult could spend life on the back end, and because of his age being 15 at the time, I'm assuming that there's something in their law that allows for them to be prosecuted as an adult.
There's a lot of evidence against him. And this is a case that got a lot of attention and continues to in Raleigh, North Carolina. You have 5 victims, including his own brother. If you were someone who is defending Austin Thompson, knowing that just from the outside, I'm not a lawyer, but like the cards seem to be stacked against him. I mean, what is your approach in terms of defending a client in a situation like this?
I think in a situation like this, of course, it's horrific. This is not something that anybody would have wanted to see happen. But we have to have a real conversation, and a real conversation with our client. What is the evidence? What are the cards that are stacked against us? Why did this happen? What is the root cause of this? And how do we address that? From as an outsider looking in, this case seems to indicate to me that this individual had some sort of mental health diagnosis, or something going on with respect to his mental health that ultimately caused him to allegedly act in this way. And we're seeing these things a lot more and more lately. So in my opinion, what would be best in this case is to actually sit down and address the mental health component of this, and use that to negate or mitigate the consequences that he could receive on the back end at a trial, or the back end of a sentence that he would face as a result of a plea. So we're really trying to mitigate the exposure. We're not necessarily negating that, he was the individual that committed this crime, but the why matters. If there's, and it depends on what statute he's charged under, there has to be intent in some instances. In some other instances, there may be a need for the mental state to be a reckless act. So it depends on what that is. And again, addressing, in my opinion, how we negate that mental health component and that culpable mental state is going to be the approach that we would want to take in order to kind of bring some resolve to the situation.
Because, of course, innocent until proven guilty. But are you going in looking? Is a defense team going in and looking for a not guilty verdict in this case? And what are some of the outcomes that they could be looking for when you look at the evidence that is stacked against him?
It is going to depend on the evidence. Do we have video footage that shows him as the shooter? I expect that there may be some testimony of individuals that lived in that neighborhood who will testify that he was the shooter. And what a lot of times people don't realize is testimony is evidence, and that is given the same weight and credibility as any other piece of evidence. For example, your video footage. But we're looking at everything that would say, in my mind as an attorney, yes, my client is guilty, or no, my client is not guilty. And so after we make that decision and determination, then we continue to go forward and say, okay, well, can we really in good faith say he's not guilty? Is that going to be our best bet? If there's a lack of evidence that shows that he's the shooter, then that's what we're going for. If there's an overwhelming amount of evidence, and after conversations with our client, if we've got a video of him actually shooting, then we have to have a different conversation that says, okay, well, we need to attack this piece of, the statute or the allegation, the intent to commit this crime. Was there actual intent? Or with recklessness, was there actual recklessness? So that's going to depend on what's in the discovery. If there's an overwhelming amount of discovery that shows, and it's clear as day and on video, that our client did this, then we have to have another conversation about how we get around. And the best way to get around is to piecemeal and attack the specific statute and the culpable mental state with respect to that.
This story received so much attention at the time, certainly in Raleigh. As you Google this case, every Raleigh news media outlet has a piece that comes up. From the defense's standpoint, is time something for them where maybe the publicity, it goes into the back seat a little bit more compared to just how the news cycle regularly goes? Is the delay tactic something that the defense also could be looking at as this trial date gets pushed out to 2026?
Absolutely. I think the most important thing for the defense right now is dealing with their client's, again, mental state at the moment. But secondary to that is, again, the media exposure. We want to remove ourselves as far apart as we can from the media. And oftentimes, the more exposure that a case has at the onset of charges being brought, there's tons of media exposure. We've got to deal with, who in the community, if anybody or everybody, has heard about this case, especially a case of this nature. And so we've got to deal with those things. Sometimes we may make a motion for change of venue because there's been so much exposure in a particular county with respect to a case. Not only that, but the postponement of these trials, in my opinion, as a defense attorney, can oftentimes go in our favor, because as you get further along, things happen. Witnesses pass away, unfortunately. People start to not remember. They start to forget, what exactly happened at a particular event. So those things can oftentimes go in favor of the defense in situations like this with respect to trial, and certainly pushing out so that, it doesn't have as much media exposure as it once did is always to our benefit.
There's a related case to this, and it involves Austin Thompson's father, Alan, who pleaded guilty in September 2024 to not properly storing a firearm. It's a firearm, a 9mm handgun that police say was used in this shooting. That reminds me of some recent cases that we've seen in the news. I think of the Crumley family in Oxford, Michigan. They were charged with involuntary manslaughter related to the shooting at the high school there. And then even recently in Georgia, community of Winder, Colin Gray, the father of Colt Gray, who's the shooter at Appalachia High School, he's actually facing 29 charges of including second-degree murder for sharing responsibility with his son. What do you make of how the father was charged in this case and compare it to some of the others that we've seen in the news in recent years?
I think that there's been a turn and a shift with respect to gun laws and the responsibility of parents in safekeeping their firearms from their children or from their teenagers. And so it's not surprising to me that dad was charged in this case, especially when you're talking about a mass shooting. A number of individuals that unfortunately are fatalities to an act of one individual gunman. And so what we're seeing a lot more now is that parents are being prosecuted for these cases and for failing to keep safe. When you're a gun owner in this country, a part of being a gun owner is to safely store your firearm. You know, each state is different with respect to how you do that. And so there's something with respect to the North Carolina laws where they're alleging that dad did not safely store these firearms, and they may be looking for some sort of accountability from dad with respect to these deaths as well. And also, a lot of times when you have individuals that have passed away as a result of these acts, there's starting to be a zero tolerance policy with respect to, failing to keep safe these firearms. So it's not a surprise here.
And now, more than 2 years since this shooting happened, there still hasn't been a motive that's been released as to why police believe Austin Thompson did this. How likely is it, when you look at some of these cases, that we could find a motive in this trial, and potentially that could be something that the defense uses when trying to appeal to a jury?
Absolutely. So during a trial, one of the things that a prosecutor is always going to try to do is they're going to try to establish motive. They're going to try to establish something that gives the jury reason to believe why the defendant committed the crime that he's charged with. And so that's important for jurors to hear, because they need to be able to reason why they are finding somebody guilty. That also establishes proof beyond a reasonable doubt as well. Now, you'll hear in trial that there will be pieces of evidence that come in that go to the individual's motive to commit the crime. Now, on the defense end, their position is more than likely going to be, again, if they challenge whether or not their client actually did this or not, our client had no motive to do this. The prosecutions failed to establish any motive or any reason as to why my client would have done this. And they're going to argue that the prosecution needed to prove motive, or should have proven motive, to find their client guilty beyond a reasonable doubt. So motive is going to come at play. Again, when you have cases where there's some type of mental health implication on a defendant, those answers may sometimes not be clear, and they may never be answered. So it's really going to depend on what angle the defense is going to take with respect to this, if there's some sort of mental health implications, and if they're going to challenge if he was even the shooter, or simply challenge the mental states and that the individual could not have formulated those in order to commit the crime.
We'll see what happens, but for the judge to side with the defense this time, pushing the trial date from September of this year to February of next year, knowing that the defendant has this brain injury the defense says he has from a self-inflicted gunshot wound, so a very, very serious brain injury, we believe. How likely is it that this trial could be pushed back even further? Or typically, is it a judge saying this is going to be the date and that's where it'll be?
At this point in time, the trial is going to be scheduled and is expected to move forward in February of 2026. However, if, as they continue to prepare for trial, the defense feels that their client is not in the position to aid in their defense, that trial date can certainly be pushed back again. There's a lot of laws in certain states that indicate, again, that an individual has a right to aid in their defense. And there are certain safeguards that if an individual cannot do that, then there will be delays, and those delays will be done by the court. There can be something that we call, and we have these in the state of New York, is 710 or 730 order. If an individual is not competent enough to stand trial, they are evaluated by a psychiatrist to determine if they can proceed forward. And if they're not, then their prosecution is suspended for the time being until they're able to gain competency. They go into a mental health facility to get treated for, whatever their diagnosis are. But in this particular case, that certainly can happen. There can be another delay, but as of now, I expect that they're going to continue to go forward with that date, unless the defendant can't aid in his own defense.
February 2026, we'll see how this trial plays out. Certainly a tragic story, one that's had a huge impact in Raleigh, North Carolina. Safa Robinson Ferrer, criminal defense attorney, thanks for diving into this with us.
Thanks, Chris. See you later.
As he awaits trial, Thompson is being held at a juvenile facility about an hour from Raleigh. If convicted, he faces life in prison because he's under the age of 18. The death penalty is off the table. We'll continue to keep a close eye on this story as it continues to develop here on Law and Crime. I'm Chris Stewart. Thanks for joining us.